Welcome to the Padilla in Practice series presented by the National Association of Criminal Defense Lawyers in collaboration with the Defending Immigrants Partnership, a national collaboration to assist indigent defenders in effectively representing their non-citizen clients. This free series of webcasts is supported by grant funding from the Foundation for Criminal Justice, the Ford Foundation, and also support from the Open Society Institute. These trainings are part of a larger effort in which NACDL has collaborated with the National Legal Aid and Defender Association to understand and educate the bar about the implications of Padilla. The free nature of all of these webcasts reflects the commitment of all of the organizations and all of the faculty involved in ensuring that defense lawyers are able to represent all of their non-citizen clients to the best of their ability. We are coming to you live today from NACDL headquarters in Washington, D.C. And at last count, we have some viewers from at least 47 states, the District of Columbia, Canada, and the Virgin Islands. So we're glad to be able to reach such a wide audience. So I would like to introduce the speakers for this session, the immigration consequences of drug offenses. Benita Jain is the co-director of the New York-based Immigrant Defense Project and leads IDP's work with the Defending Immigrants Partnership. Benita also monitors and analyzes legislative proposals affecting immigrants who have interacted with the criminal justice system, and she has supported IDP's litigation efforts. She's written several pro se guides for immigrants fighting deportation, and she's an original co-author of the Deportation 101 curriculum. She's been with IDP since 2003. Dan Kesselbrenner is the executive director of the National Immigration Project. He's a nationally recognized expert on the immigration consequences of criminal convictions and on contesting deportability in immigration proceedings. Dan is co-author of Immigration Law and Crimes, which was cited in the 2010 Supreme Court decision, Padilla versus Kentucky. He has also authored numerous articles on immigration law and trained thousands of criminal defense lawyers and trained judges on immigration consequences. Dan has directed the National Immigration Project since 1986. So now I will turn the program over to our faculty.
Great. Okay, thanks, Vanessa. So we wanted to have a session in the Padilla in Practice series specifically for drug offenses because they're some of the most frequently prosecuted offenses for you all, for criminal defense, that criminal defense lawyers see. And they're also one of the most common grounds that lead to deportation. In addition to being one of the most common grounds that lead to deportation, drug offenses, unfortunately, can also be some of the most unforgiving in immigration law. So that's the bad news. The good news is that there are actually some very, very practical things that criminal defense lawyers that you all can do to put your client in the best position possible to either avoid deportation or have a fighting chance at avoiding deportation. And in addition to that, as we've spoken about before, both because of the Supreme Court decision in Padilla v. Kentucky recognizing the Sixth Amendment duty to advise your client of immigration consequences, and because you want to zealously represent your clients, you want to have the information you need to be able to inform your client of immigration consequences of potential guilty pleas and decisions that they'll be making in the criminal case, and then again, to mitigate where possible. So let's start. We want to start off by just doing a little review. As I mentioned, drug offenses can have drastic immigration consequences, and that applies for lawful permanent residents as well as for undocumented immigrants. In this session, we want to do a couple of things. One is we want to identify the realm of safer havens in drug offenses. So what are the types of offenses that will are safer for your client, that will not lead to deportation, and where you cannot, where you don't have the possibility of either pleading or using a safe haven type of offense? What are the types of offense that will leave your clients with a fighting chance? Meaning they'll either be less of a risk that they'll be deportable, or again give them a fighting chance in immigration court. But let me ask folks out here, and for people that are watching this on video, just think to yourselves for a second. When you're thinking about, if your client is a lawful permanent resident, what are you trying to avoid? Are you trying to avoid the grounds of deportability, or are you trying to avoid the grounds of inadmissibility? Deportability. So, we have someone here who just said the right answer, which is deportability. And just to review, remember that immigration law has certain grounds of deportability that will result in someone who has legal status being kicked out of the country, including lawful permanent residents. So your lawful permanent resident clients are most interested in avoiding the grounds of deportability. How about undocumented? If your client is undocumented, so they've overstayed their visa, or they came across the border and never got status, or if your client is undocumented, what types of immigration offenses are you trying to avoid? Deportability grounds or inadmissibility grounds? And for folks who are watching this on the webinar, I just take a second and see if you can, what the answer is. Think to yourself, or say it out loud to yourself. How about anyone here? Inadmissibility, the other one, right? So if your client is undocumented, then first and foremost, you'll be trying to avoid the grounds of inadmissibility. Okay. So for lawful permanent residents, as we just mentioned, you do want to avoid grounds of deportability. If you can't avoid grounds of deportability, you want to avoid the mandatory deportation grounds. So the grounds of deportability that will foreclose relief for your client. And although they might still be deportable, they'll at least be able to apply for some kind of a waiver from deportation. So in Mr. Padilla's case, in the Padilla v. Kentucky case, for example, the Supreme Court noted that his plea would subject him to deportation without relief. For lawful permanent residents, just one example of the type of relief that we want to preserve if the person will end up being deportable is cancellation of removal. And we're not going to go into details about what makes someone eligible for cancellation of removal, but we will talk about the types of offenses that will foreclose that as an option. Okay. So when you're looking at deportability for drug offenses, you want to think of two things. One is the drug offense a controlled substance offense under immigration law? And then you want to think about, is that drug offense a drug trafficking aggravated felony under immigration law? And we'll go through each one of these in turn. So controlled substance offenses, the site is in the PowerPoint. In order for your state, for your the offense you're looking at to be considered a controlled substance offense and fit under that ground of deportability, your client would need a conviction relating to a controlled substance offense as defined in 21 U.S.C. 802. And there's an exception for a single offense for simple possession of 30 grams or less of marijuana. Okay, so conviction relating to a controlled substance offense, unless it's one-time simple possession, 30 grams less of marijuana. Okay. So what's considered a controlled substance offense? The statute refers back to the schedules under the Federal Controlled Substances Act. So one thing you want to do at some point is to compare your state's drug offenses, look at what types of controlled substance offenses are covered under your state's criminal laws, and compare them to the federal schedules. Because again, in order for a drug offense to be a controlled substance offense for immigration purposes, it has to include one of those federally covered drugs. Okay. So if your client is convicted for an offense involving a federally covered drug, is that considered a controlled substance offense? Yes, right. It's considered a controlled substance offense and your client will be deportable. What if the conviction is for possession only? Will your client be deportable, generally speaking, for possession of a controlled substance offense? Yes, yes. Yes, so possession can be a controlled substance offense, and that will make your lawful permanent resident client deportable. How about possession with intent to sell? I'm sure you guys are seeing a pattern here, right? It's a controlled substance offense, will make your client deportable. Excuse me. How about sale or distribution of a controlled substance offense? Is that a controlled substance offense for immigration purposes? Yes, and yes, deportable. All right, now let's think about marijuana possession.
Actually, Benita, before you get into marijuana possession, what happens if it's not a federally controlled substance?
So if you're, if it's not a federally covered controlled substance, then it won't fit under the definition of a controlled substance offense ground for immigration purposes. Does that make sense to everyone, or does anyone have a question on that? So if your state has an obscure drug that they think is bad and the federal government doesn't, so they don't criminalize it, that might provide the opportunity for having a safe haven, right, if your client's pleading to that. Okay, marijuana possession. How about your client is convicted of simple possession, 30 grams or less, personal use, one-time conviction? Will your client be deportable for that? No, right? So we heard no. That's right, because it's an exception to the controlled substance ground of deportation, and your client will not be deportable. Remember, it's got to be only one time, and that is what we would call a safer haven.
And just to be clear, the reason we're using safer haven is that the prohibition against ex post facto laws doesn't apply to immigration proceedings, which are civil. So if Congress tomorrow changed the definition of what makes a person deportable for controlled substance to include simple possession, first-time use of 30 grams or less of marijuana, and they made it clear that they wanted that to apply retroactively to convictions that had already been obtained, that person, under prevailing Supreme Court precedent, could be found deportable. So really, all you're doing, which is pretty significant, is giving the best assessment you can after looking at the law as it is now. And really the only way for someone to remove that slight doubt is to go to trial or to get the state to drop the charges. So that's why we have that qualifier safer as opposed to safe. Now chances are Congress isn't going to do that, but obviously you and your client, you want to be as clear as you can that I'm just telling you what the law is, my understanding of what the law is now, and that's what you really need to base your decision on.
Yes, that's a really good point. One other reason why we use the term safer haven instead of safe haven is that right now, in this section, we're talking about grounds of deportability, right? So if a lawful permanent resident has just this one conviction, one-time simple possession of 30 grams or less of marijuana for personal use, they will not be deportable. So once they're in the U.S., they won't be able to be kicked out. It could potentially impact their ability to travel abroad and return from travel abroad and other things, which we'll go into a little bit later. But for purposes of, as Dan said, the law right now, will they be kicked out while they're in the United States for being deportable? This is the safer haven. Okay. What about conviction for paraphernalia? Do we think that a conviction for that may be a controlled substance offense leading to deportation? So in the room here, I see heads shaking yes, and the answer is yes. Paraphernalia would be a controlled substance offense that would make your client deportable. And there is one exception. It's not written in case law. I'm sorry, it's not written in the statute, but through case law, we should feel fairly confident that one-time conviction for possession of paraphernalia that relates to 30 grams or less of marijuana would fit under that 30-gram marijuana exception for deportation that I just mentioned. So paraphernalia, normally deportable, controlled substance offense. One-time paraphernalia relating to 30 grams or less of marijuana should fit under the exception. Okay. And then as we mentioned before, a conviction for a drug that is not covered under federal law, not a controlled substance offense, not deportable, safer haven. Okay. So we want to take a couple minutes to do an exercise. So if folks can take just a couple of minutes, including for those who are watching on the webinar, read the statute and consider whether a conviction under this statute will make your client, who's a lawful permanent resident, deportable. And if it's okay, we'll just take a couple of minutes so folks can do this exercise. Okay, so that was an extra quick couple minutes, but just to then read this, you're in a state where the statute your client is being charged with is criminalizes possession of a small amount of marijuana for personal use, possession of a small amount with intent to distribute, and distribution but not for sale. And for purposes of this, small amount means 30 grams or less of marijuana. So does a conviction under this statute make your green card holder, your green card holding client deportable? Does anyone want to take a stab at this here?
I guess it depends on the statement of facts or the offer of proof. Or...
Yeah, it depends, right? I mean, that's a great answer. It depends. It depends on exactly what your client pled guilty to. It depends on whether he had priors or not. So remember, when we were talking about the different types of drug offenses that could fit under the controlled substance ground of deportability, we talked about the difference between well, we haven't yet talked about too much about the difference between possession and sale, but we talked about the difference between one-time possession of a small amount of marijuana versus more. So if your client pled guilty to subsection 1, the possession of a small amount of marijuana for personal use, and your client had no priors, then that would fit under the safer haven, right? It would fit under that one-time marijuana, small amount of marijuana exception. If your client already had a drug conviction before that, and then they pled guilty to possession of a small amount of marijuana, then they can't take advantage of that exception. And pleading guilty to this or being convicted of this will make them deportable. And then sections 2 and 3 we see are more than simple possession, right? There's possession with intent and there's distribution but not for sale. Either one of those would be a controlled substance offense that doesn't fit under the marijuana, small one-time marijuana exception, and will make your client deportable. Okay. Does that make sense to everyone, or do folks have questions on this right here?
We did get a question online about whether bath salts under Florida law is a federally controlled substance or not. And basically there are several pages of definitions under the federal statute as to what's controlled and what isn't, including things in the federal code of the federal regulations. So I haven't memorized all of the federally controlled substances, but what one would need to do is to compare the list of federally controlled substances, see if bath salts were there, and if it weren't, then it wouldn't be federally controlled. I mean, I don't mean to not answer the question, but I think it's the rare person, if anyone, who's actually memorized all of the different offenses that are codified in the statute and the regulations promulgated under the statute.
Okay, so going back to this exercise for a second, how can you tell what your client was convicted under, right? Or what might an immigration judge, considering a deportation case, look at? And here we just want to do a review of the record of conviction, the documents that an immigration judge normally would be able to look at when faced with a statute like the one we just used in our exercise that includes separate, distinct offenses. And again, the record of conviction includes the statute and case law, on the statute includes the charging documents to the extent that they're incorporated into the plea, the written plea agreement or oral allocution, the plea allocution, the judgment, sentence, jury instructions. These are the pieces that an immigration judge would be able to take a look at. So in your case, if your client is facing, going back to the exercise charges under the statute, what can you do to best protect your client? We've said that the safer plea, if your client is certainly going to plead to something, would be one, the possession of a small amount of marijuana. So what you can do is clarify that your client is pleading guilty to subsection 1. Again, you could do it in the allocution or, just in one of, so it's clear from the record that they're pleading guilty to subsection 1. That would be the safest thing that you can do. If you can't, for whatever reason, make it clear that your client is pleading guilty to subsection 1, then the second best thing to do is to leave it ambiguous and leave open the possibility that they may have pled guilty to subsection 1, so it's not foreclosed. What you don't want to do, if you can at all avoid it, is make it clear that your client is pleading guilty to the sale or distribution, right? Or that your client is pleading guilty to more than 30 grams. And then the record of conviction normally would not include things like police reports or probation reports, although, if your client stipulates to facts in some of these documents and they're incorporated by reference into otherwise a record of conviction, then they would be considered part of the record of conviction for immigration purposes.
And just to give a sort of practical illustration, if your state statute doesn't distinguish between small amounts of marijuana, the conviction is the same, let's say, from 0 to 60 grams, the district attorney might not care if you plead to 29 versus the original charge, which may have been 33, if they introduced the thing from the lab, so that they could agree in order to get the plea to an amount that helps your client but doesn't mean necessarily anything to the prosecution. Those are the kinds of situations that you may be most apt to get the district attorney willing to go along with your suggestions if, it's basically 6 of one and a half dozen of the other to the state or the Commonwealth, whether there's what crime the defendant pleads. Okay, we're now switching to drug trafficking aggravated felony, this is the Immigration Nationality Act site, but it's also at 8 U.S.C. 1101A 43B. It includes any illicit trafficking in a controlled substance as defined in Section 102 of the Controlled Substances Act, including any drug trafficking crime as defined in Section 924C of Title 18 of the United States Code. If you go back to this, when you see that this creates two alternate kinds of definition. One is if it comes within the general meaning of trafficking, which is the first bullet point, and it involves a controlled substance. And the second is if it fits the federal definition of drug trafficking crime, which is provided in the Title 18. Now, in turn, Title 18 defines a drug trafficking crime, and this is a sentencing enhancement statute, as a felony punishable under the Controlled Substances Act, the Controlled Substance Import and Export Act, or the Maritime Drug Law Enforcement Act. All of this is a long way of saying if it's listed under one of these statutes, and under these statutes it's punishable as a felony, which is something punishable by more than a year, then it's a felony punishable under 18 U.S.C. 924. This issue went to the Supreme Court as to what drug trafficking was, because a lot of people said that, well, under Missouri law, possession is a felony, And if you look under those laws, it covers possession, so it should be an aggravated felony. Fortunately, the Supreme Court rejected that view. And what really matters is that it has to be a felony punishable under federal law. Means if you look at those three statutes, can you be convicted under as a felon or not? And so that a state felony drug conviction isn't always an aggravated felony. That's the takeaway. That you don't want to, one of the things that's both a challenge and an opportunity about doing this kind of work is that there may be things that are sort of bad or mean one thing under your state statute and are settled law under your state statute. But when you transpose or put that person in the shoes of someone who's, has a federal overlay of immigration law applied to them, the outcome may be different. And this is one of those areas that you could have state felony possession. It's not an aggravated felony. Why? Because with one exception that we'll get into in a second, first-time possession of a controlled substance is a misdemeanor under federal law. So, in drug trafficking, as I said, the question is the state offense punishable as a misdemeanor or a felony under federal law? This is the one exception these days. Simple possession of any amount of flunitrazepam, which is a date rape drug, is a felony under federal law. So one thing that should jump out at you, and it also works the other way. Let's say your state has flunitrazepam, which is also known as roofies, as a misdemeanor. Your client pleads to misdemeanor possession of flunitrazepam, even though she or he's pleading as a misdemeanor under state law. When you look at, is this punishable as a felony under federal law, the answer is yes. Why? Because the one thing that Congress has singled out to punish a first-time possession as a felony is possession of flunitrazepam. So you really have to not look in terms of how your state treats it, but think of this federal overlay. Sometimes it'll be more generous than your state law. Sometimes it'll be more harsh. But in both situations, they're still going to apply the federal test. Recidivist possession sometimes is a federal felony. And by recidivist possession, we don't just mean having two convictions for a controlled substance offense. You have to have been both charged and prosecuted as a second or subsequent offender. So if your state has a statute, you punish, it's called first-time offense, and then it's second or subsequent. If you can get your client to plead, get the prosecutor to let your client plead not under the second or subsequent, then that person is not guilty of recidivist possession. Why? Because it doesn't just mean any two convictions. It means that you were convicted under a statute that punished you as a repeat offender. The other kinds of things that are punishable as felonies, that almost all manufacturing, distribution, possession with intent to distribute are treated as federal felonies. So any federal felony drug conviction is an aggravated felony. It's not only is the person deportable, it's probably mandatory. Now, if there's a state drug conviction for an offense, I think I mentioned this, that federal law punishes as a felony, it's also an aggravated felony, and the person will face probably mandatory removal consequences. I want to point out at this point that it isn't the name of the statute that matters. So, for example, Texas, a published case on this, Texas has a statute that's called, delivery of a controlled substance. So if you just looked at the name of that statute, you'd say, oh, well, delivery is punishable under federal law. It's a felony to deliver a controlled substance under federal law. That applying this test I just gave to you, one might assume that any conviction for Texas delivery is an aggravated felony. It's not true. Why? Because the Texas statute includes an offer to sell. An offer to sell. So if you're lining up, is every crime that's defined under Texas law a federal felony? The answer is no. The offer to sell a controlled substance isn't listed on the list of federal crimes. The takeaway from this is, there are two takeaways. One, and again, this could work both ways. You could have a relatively benign sounding statute that included only things that were problematic. Or you could have something that sounds like as if it should be, in quotes, an aggravated felony. But if you actually, line up the elements between, what's punishable under the federal statutes as a felony and your specific state jurisdiction, you might find, like in Texas, that you have a statute, a crime defined under the law like an offer to sell, which won't make your client guilty of an aggravated felony necessarily. The good thing about this is, if it's in the same statute, the prosecutor, again, might not care. And that's really the way you can, just throwing out these examples, because I think, to hear some tips, even if that tip may not exist in your jurisdiction, that's the sort of line of thinking or approach that really would enable you to make a big difference in your client's cases. Okay, what about simple possession of first offense? Again, unless it's flunitrazepam, it's not an aggravated felony. But, and this is just to be clear, which I don't think I've said before, but maybe Benita did, you are still deportable under the test that she laid out for something like an offer to sell a controlled substance. Why? If the person's not a citizen, they've been admitted, it does relate to a controlled substance. It's just you're not included under this definition of aggravated felony, which has, in general, far worse consequences than being deportable for a controlled substance. In other words, again, it's a little bit beyond the scope of what we're talking about, but you can be eligible for kinds of relief for removal or mitigation if you're deportable for under the controlled substance ground, but you're not deportable under the aggravated felony ground. So there's sort of this, generally speaking, this hierarchy that you want to, if you can, avoid deportability altogether. If you can't do that, you want to try to have the person deportable in a way that still gives that person options when DHS tries to remove them from the United States. And if you think about it, in fact, in Mr. Padilla's own case, Mr. Padilla, for that drug charge, the Supreme Court was focusing on avoiding possibly an aggravated felony because he'd been a longtime permanent resident, and Mr. Padilla would have been able to get relief or eligible for relief had his lawyer pled out to possession. So, to me, the takeaway is, even though your client may still be deportable, there is, as I said, a hierarchy, and you want to make, if you can't avoid deportability altogether, you want to have your client, let your client know that there may be a way to plead to something which, although they might be deportable, will give them something to argue when they're in immigration court. Okay, simple possession, second or subsequent. Again, I mentioned this, there has to be no finding of a prior drug conviction or recidivism. If that's the case, it's not an aggravated felony. In other words, as I said before, if you're charged and convicted under a second or subsequent statute, there's a chance it's an aggravated felony. If you're charged as a statute which doesn't charge you as a second or subsequent offender, that is, they let you plead to straight possession twice, then it can't be an aggravated felony. That's, there was another, this issue also went to the Supreme Court, and this was, won at the Supreme Court. So and there are other sorts of rules like, that the prior should be at issue in a subsequent case. There should be some notice that they're going after you as a repeat offender. And in those cases, it may be an aggravated felony because the exact parameters of when a second offense, recidivist conviction makes you an aggravated felony are still to be determined. But if you're not convicted as a subsequent offender, it can't be a recidivist aggravated felony. Okay. Sale of drug, aggravated felony, mandatory detention. Offer to sell is, as I mentioned, a safer haven. There's in the Fifth Circuit it's not, and this is one of those things that I think it's important to mention. We realize that none of us can save everybody. And that in most instances, and you all, criminal defense practitioners, have a very difficult job. And sometimes, where the prosecutor has a, slam dunk case against your client, and if the person went to trial, there would really be nothing that anyone could do. Now, it's still possible you could get a, jury that would, jury nullification and that people would feel sorry for your client. I'm not discounting that. But I'm just saying, if you look at the, what they have, what their evidence is, if 99 times out of 100 your client goes to trial, she or he's going to lose, in that situation you could say, well, one possibility is that there's some authority that if we plead you to offer to sell, you're not going to face mandatory deportation. Most people, obviously each individual gets to make the choice for himself, but, I think most people would appreciate that you were doing a good job for them by keeping the possibility open. Okay, what about giving away a small amount of marijuana? Again, it falls into the same framework as that I just mentioned about the offer to sell. It's possibly an aggravated felony. Again, it's good to try to foreclose, to actually plead affirmatively to the most benign conduct that makes your client guilty under the statute. So let's say there's a statute that punishes giving away marijuana and selling marijuana, and you're punished the same way regardless. If there's a factual basis, or if your court will let you plead to giving away, then you're in really, really good shape. You have that the immigration lawyer or the person can make the argument in an immigration court. It's the less safe alternative, as we mentioned, is to keep the possibility open, but that probably won't work. The things that are still unclear are what's a small amount, and who has the burden. There's a split on the circuit on the burden issue, since this is a national broadcast and it's a general session. We're not going to sort of describe that split in any detail, but you might want to check on the law in your circuit. Again, as the reminder, this whole section I've been talking about is a way to avoid getting an aggravated felony drug trafficking offense. That, any offense which, it relates to a controlled substance that's on the federal list will make your client deportable under the general controlled substance ground. But for some of your clients, particularly those who've been permanent residents for a long period of time, avoiding the aggravated felony deportability or the conviction for an aggravated felony will, in general, be a thing to help your client preserve eligibility for relief. Okay, we're going to do this?
Sure. It's some of the other.
Okay, so let's go over some of the possibilities of what would make something a safer haven. Well, one thing is, if you can, allocate affirmatively to one of those substances that's not on the list, that would work. Chances are that's pretty difficult. Another thing you could do is plead, is to not, is to keep the record ambiguous. So in other words, it may be that in your jurisdiction they just charge a violation of the statute. So they said, you're guilty of intent to distribute a controlled substance under the laws of our state. And they don't say what the drug is. Most places will say, to wit, cocaine, or something to that effect. In any situation where it doesn't say something like, to wit, cocaine, or the substance is nameless, for immigration purposes, you don't want to fill in the blank, because chances are filling in the blank is not going to be one of these obscure steroids that isn't yet on the federal list, but it's going to be one of the sort of, drugs that's squarely there. Again, I don't know how often this happens, but I have seen it happen. From a criminal defense point of view, it might be better to, even argue you want a motion for a more definite statement or something which would clarify that it is what the drug is, or whatever your mechanism would be under your state law, or to go to trial and say they haven't proven it. But for immigration purposes, the act of identifying what that substance is and having it be included as a substance that's federally controlled under 21 U.S.C. 802 would be probably the kiss of death for the immigration case. The other thing is, it's possible if you have a broadly worded statute that includes, and I've seen this, it used to be in Florida, but they amended it, used to be that possession and distribution were punishable under the same statute. In that case, if you just plead guilty to the statute as charged, you can't necessarily tell, what the government's theory was, because they didn't really identify what it was. Similarly, sometimes they'll say you either possessed, delivered, sold, manufactured. It'll be listed in the, as a string of things. If you can, you want to, again, this is some of its repetition, you want to affirmatively plead to the most benign thing possible, which would be the possession. Again, the idea is, you want to have the record be as helpful as it possibly can. In order to do that, you need to know where the line is drawn between what's helpful and what's harmful, and to the extent you can, try to get the record of conviction to fall within the helpful end of the scale. You also, as I said, if it's a recidivist charge, see if you can be, you can move it or plead it to simple possession under a statute that doesn't treat the defendant as a second or subsequent. And finally, if it's, an offer to sell, in the Fifth Circuit and elsewhere is not a aggravated felony, and it's the risk in that is more, because it really isn't on the federal list, it's whether that the case law hasn't been developed in some places, and the government would probably charge your client. Another one is that, giving away a small amount of marijuana. But in general, except for the first bullet here, chances are, if the substance is identified, it is federally controlled, that it will relate to a controlled substance. Because again, the standard for when you're deportable under the sort of general controlled substance ground is any law that relates to a controlled substance. Here we're talking about something which is classified as a drug trafficking crime under federal law, or something that involves illicit trafficking.
Maybe we skip the exercise.
Yeah, okay. You doing the next thing?
So we're going to skip the exercise on the PowerPoint, but folks should definitely feel free to do it on their own. So just to kind of wrap up the deportability grounds section, again, you have a client, you've figured out the first most important thing, which is your client's immigration status. Your client is a lawful permanent resident. That means you're looking at the grounds of deportability. How are you looking at this case? So first and foremost, you're trying to avoid the controlled substance offense ground of deportability, and that means ideally you want to avoid any drug-related conviction, period. If you can't do that, you're trying to specify a substance that's not covered under under federal law. And if that's impossible, you want to keep the record clear as to exactly what substance was involved. And again, this is going to help only in states where your state covers a drug that the federal drug laws do not cover. And again, in order, if you cannot avoid a drug conviction, and it's a marijuana case, and the client has no priors, then you can take a possession for personal use of 30 grams or less of marijuana. Put that on the record if you can. If you absolutely can't put that on the record for some reason, leave the record ambiguous. Okay. And then if you can't avoid a controlled substance offense, ground of deportability, then you at least, which means so your client will be taking some kind of a drug conviction, then absolutely you want to avoid the drug aggravated felony ground, if at all possible, to preserve relief. And, Dan just talked about all of this, so I'll go through this really quickly. Plead or limit the record to simple possession. If there's a prior final drug conviction, try to avoid the recidivist finding. And then, the things that are risky, but possibly leave an opening in immigration court are pleading to offer to sell or gratuitous distribution of small amount of marijuana.
I mean, the other strategy that I would suggest, which may be possible in some jurisdictions, especially for first-time offenders, is is to avoid a conviction altogether, and that there may be for there to be a conviction under immigration purposes, there has to be under one of these deferred adjudication schemes, there has to be a plea of guilty, an admission to sufficient facts, and some form of restraint on the defendant's liberty. So if, many jurisdictions have something called, pre-plea diversion. And if you can plead to a diversionary scheme that doesn't require your client to admit in open court, the charges, or doesn't require an admission to sufficient facts or some equivalent finding that a judge would make of guilt, your client can then take on, things that the state might be interested in, like, some sort of rehab program. And even though that rehab program, you need both of those prongs for the person to be convicted. So if you never have a plea in court, but you have some sort of rehabilitation or something which the state satisfies the state that your client's not going to reoffend or isn't continuing to offend, that can be avoid deportability too. And the reason I say that to the extent that the more equities the person has, that might be, and also this depends on jurisdiction, that might be the kind of thing where a prosecutor would say, yeah, since we'd normally give this person, whatever it is in that state where they have to, admit sufficient facts and go to the program, which would be a conviction, we'll say, we'll devise something so that you can do get the benefit of the program without having to admit something in court so that you won't be kicked out of the country. And that a lot depends on advocacy, but that's something to keep in mind that wasn't in the materials.
And just the one other thing to add, two really quick things to add about aggravated felonies. One is, remember that in order for an offense to be considered an aggravated felony under immigration law, your client doesn't have to have been sentenced to anything, right? So if your client has one of the offenses that Dan just talked about that's considered, that's a sale or distribution offense, or the first-time flown in transit possession, et cetera, and the judge decides, for whatever reason, no jail time, that's still an aggravated felony. Second thing is, if you're in a situation where the only offer on the table for your client is to an offense that would be considered an aggravated felony under immigration law, then the conversation that you're having with your client is, look, if you accept this, you plead guilty to this offense, it's considered an aggravated felony under immigration law. That means that you will be subject to deportation. You will not be able to apply for cancellation of removal or other forms of relief that let you keep your green card. You will have a permanent bar on applying for citizenship. You will face mandatory detention. Don't know where you'll be detained. There's no, there's no way to guess for how long or where. And based on all of that, then your client is deciding with your counsel, do they still want to plead guilty to that? Or given the rest of the, whatever situation, whatever evidence there is in the criminal case and possible jail time, would they prefer to go to trial, right? So it's a very different conversation that you're having with your client if the only offer on the table is an aggravated felony. Do we want to?
Well, we did get a question. The question is, what if your client pleads to possession of a substance not on the federal schedule but later added to the schedule? Is he deportable? Since there's nothing you could have done differently, this is really like an immigration question. My guess is it depends on how clearly they intended for that to apply in earlier to things that preceded it. And since it wasn't controlled at the time, I think the immigration court, the person would have a really strong argument that since what they do is add these substances to the list periodically. And if your client pleads on, January 31st, 2012, and something's not on the list, it's later added, the presumption that that's intended to apply only to convictions on that date subsequent would apply because they're not going to have express language that says it's retroactive. So absent an express language or intent that something's supposed to reach back into time, it doesn't reach back into time. So some of it would depend on but if it was just sort of automatically added, then, you'd have a really good argument. Do you have anything to add to that?
No. So that's yours, undocumented?
So now we're going to switch to talk about people who are undocumented. So undocumented clients, the test, what they're mostly caring about, as we heard, was inadmissibility. Inadmissibility has to be a controlled substance offense. Again, this is that same 21 U.S.C. 802 is referenced as the benchmark. But it also includes reason to believe that someone's a drug trafficker. For your purposes as criminal defense practitioners and for Padilla purposes, the best thing you can do is to, if you get the result not to be a distributive offense, you've basically done as much as you possibly can because this ground doesn't even require a conviction. So we have this here, so you would say to your client, look, if you're found with 500 pounds of marijuana and we get you to plead out to possession without sale, there's still some exposure that you're going to be found under this, inadmissible under this ground that doesn't require a conviction at all. From your point of view, all you can do is get the person off from the charges, and let the person know, for example, if they're, that this risk still exists. Even if you get a not guilty on that, they could say, we meet the test for reason to believe. So there's really very little people in the criminal defense context can do. This is more just like I guess the gray cloud and the otherwise silver lining of getting the charges, thrown out, is that there's some residual exposure that you can't really deal with. And do you know of any way that a defense practitioner can sort of, other than get a not guilty, to the extent you can get something on the record that it wasn't in your possession, that helps. There may be sort of letters that, but generally speaking, this is something that doesn't require a conviction at all. Okay, so controlled substance offense. There's also a ground of inadmissibility for any, conviction for a controlled substance, relating to a controlled substance, or admitting the essential elements of a controlled substance offense. For the grounds of inadmissibility, there's no 30 grams of marijuana exception. And again, this admission really refers to out-of-court admissions. So it's more like, if you get your client off, you should give your client a heads up. By the way, if you go in and say to these people, I had the smartest lawyer in the world, she got me off from this charge, and now there's nothing you can do, and I really had all these drugs, and they were mine, and I was going to use them, and aren't I lucky that I had such a great lawyer? Well, the person may have been lucky that she or he had such a great lawyer until they just admitted the essential elements of a controlled substance offense, for something that wasn't connected, was independent of the criminal case. Again, the only thing I would say to you is a word to the wise, and and this probably makes sense in general, to try to get your clients not to speak, about things, and to keep mum, because if you do, then that they shouldn't be able to use that ground. Again, that's also no conviction required.
So don't put it on Facebook, don't talk to ICE, don't put it out there anywhere where immigration might be able to get it. And just the one thing I wanted to add about the controlled substance offense ground is, remember, there's a difference between for a green card holding lawful permanent resident client to be deportable for a drug conviction requires a conviction. For an undocumented client or someone else who wants to get lawful status or is subject to the grounds of inadmissibility, a conviction or an admission will trigger that controlled substance ground. So lawful permanent resident needs a conviction. Someone else who wants to get status, an admission may be enough.
I mean, the other thing I would say is, let's say, you want a motion to suppress under that for when your client was found with lots of drugs. Doesn't happen often, but it still happens every now and again. There was that reason to believe ground of inadmissibility. If your client leaves the country after having committed a crime and comes back, that's another time the grounds of inadmissibility would apply. So in that situation, you would say to your client, if you want to keep your green card, don't leave the country. Because if the person stays in the country, they need a conviction. If they leave and come back when they're at the airport or the other port of entry, the grounds of inadmissibility will also apply to someone who's committed a crime that makes them inadmissible, and reason to believe you don't even need a conviction. Okay, so the government, what is reason to believe? We have a question.
Oh, could you give a concrete example, like a real life example of when immigration was used as reason to believe to trigger the
Well, I think that, let's say your client was found with lots of drugs. They left to go on, vacation. They came back. That would be an example where they say, you weren't convicted of anything, but because we have a police report that says, and we're going to bring in the officer who found this marijuana in your trunk, we think that furnishes a reason to believe. Another example would be, let's say your client is, married to a United States citizen, and the United States citizen can petition, if it's a legitimate marriage, for, her or his spouse to get their own green card. When you're, as Benita mentioned, when you're trying to get a green card, they apply the grounds of inadmissibility to you. They would then say, oh, we see you have an arrest record, and the arrest record shows that you were found with 500 pounds of marijuana in your trunk, and you had a great lawyer and got off. That may be helpful to you in your criminal case, but we have a reason to believe that you were a trafficker.
We did have another question from our viewing audience, just following up on the point about tell your clients not to speak to ICE if they come see them in the local jails, which they do in some places. Are you aware of consequences for not speaking to them? In other words, will that result in them being held longer, or any adverse consequences if you tell your client, sit tight, and when the ICE comes, they don't speak to them?
In jail, when ICE comes to interview somebody in jail, it's often through the criminal alien program. We've heard so many instances of deportation officers, ICE officers, telling the person who's in jail, if you don't talk to me, it's going to make things worse for you, right? Just tell me what happened, and and you'll have no problem. If you don't tell me, then I'll go after you. I'll go after. So we've definitely heard of ICE officers saying all of these things, but the fact is, if a person does not want to talk to ICE, if they don't want to talk to ICE in jail, they don't have to. And B, anything they tell ICE in jail, ICE will use to deport them. Now, if there's, let's say the person is a citizen, right, or has a strong case that they have derivative citizenship through their parents or something like that, in situations like that, it would be good to talk to ICE, right, to tell them. But in terms of any kind of negative ramifications from not talking to ICE in jail, I suppose it could affect how personally that particular ICE officer decides to go after a person, but I think in 99.99% of cases, most immigrants that ICE wants to talk to will be better off not giving ICE information and making statements that will be used against them. I don't know if you have anything
I agree
to add.
completely.
So what we usually say is that folks should say to their clients about ICE in jail is don't say anything, don't sign anything, don't lie, because that can also be used against you. And if you feel compelled to say something, because it's difficult, right, being in that situation where ICE is trying to talk to you and you're inside, then just say, I want to talk to my lawyer, I want to talk to my lawyer, I want to talk to my lawyer. But besides that, don't say anything.
And we and other organizations have prepared, sort of cards or materials that you can give, your client, and we're happy to sort of, make them available through NACDL, which would make it easier to not talk. And the other benefit, the cards also say things like, and if I end up making a statement, it was coerced. Again, the person still has to give the agent the card, and that's a very difficult thing to do. Obviously look at the power dynamic. You've got the person basically in custody. It's asking a very, big thing. Can we guarantee that there won't be some, mistreatment by the holding facility? No. Because lots of times people get disciplinary infractions for things that, in the real world that shouldn't get disciplinary infractions. But they say, well, you didn't cooperate with this, agent who was coming. That's, we treat that as an infraction. Again, I have a fairly vivid imagination. I might be able to spin out scenarios where someone could get, harmed, but by and large, once the person talks, it's very, very hard to get it back. If it turns out there's some reason that he later wants to talk, it's much easier to speak then, rather than, the converse of having said something and then wanting to retract it. I see that we've,
Run out of time.
You have a little more
oh,
time. Go
okay.
ahead.
So we did this, we're gonna skip this, right?
Sure.
Just to sort of summarize, and again, realize that, is this me? You have very, very, a lot of the things, this is a wish list, or the best possible things, and we realize that all you can do is your hardest, try your hardest, and that sometimes, it's not going to be able to result in a favorable outcome for your client, but that's, if you've done all you can do, that's all you can do. So again, in the best practice, avoid any drug-related conviction, plead to something else. If they're interested, if there are two things on the table, one of which doesn't have a adverse immigration consequences, one of which is a drug offense, structure the deal to get the plea to the non-deportable offense. If they're looking for a certain period of time to get out of your client, and most people who plead to a misdemeanor don't get any, and they're willing to give up a felony, you can say, well, I'll take a year on this misdemeanor that isn't going to cause me problems in exchange for, a felony that will. Or I'll take do whatever the time is, because if your client's concern is avoiding immigration consequences, then you're there to, the result may be horrible. If it were a citizen, you wouldn't want them to do a day more than they had to. But for a non-citizen, if his priority is avoiding adverse immigration consequences, sometimes things which might be odd or seem strange or not in the citizen client's best interest might be in a non-citizen's interest.
And just one really quick just example of that. So if your undocumented client is facing a drug charge and a simple weapons possession charge, in many cases the weapons possession charge may be hands down better than the drug charge for your client to be able to get legal status later on. And just one additional thing in terms of taking more time, in many cases taking more time but to a better offense for immigration purposes helps. For undocumented clients, you also have to remember that any contact with the criminal justice system, so time in jail, prison, probation, whatever, the more the contact, the more the likelihood that ICE will be able to identify your client as someone who's potentially deportable. So you're also sort of juggling those two things.
And some of these strategies should sound familiar because, the same strategies work in an analogous situation. It's just that the burden can be different under inadmissibility. So here, it's more important that you specify a substance, or you foreclose the problematic ground by pleading to a substance that's not covered. If you can't avoid a conviction and the person is, has a citizen or lawful permanent resident, parent or spouse or child, and they can get a visa in the future, it may help to limit the offense to a single, and it's a first-time offense, to simple possession of 30 grams or less of marijuana. As I mentioned, you can negotiate diversion without a guilty plea to avoid a conviction, offer an alternate plea to a freestanding accessory offense. In some cases, the plea to an accompanied non-drug charge may be better, which we just mentioned 10 seconds ago, and I think we have to stop, unfortunately.
Then the last thing that I would add is in terms of resources. Again, we would encourage everyone to go onto the Defending Immigrants Partnership website. That's defendingimmigrants.org. And DIP is a national collaboration that's been working with public defender offices and in-house immigration experts at public defender offices to help them set up immigration protocols. And there are tons of resources designed for criminal defense lawyers who are trying to figure out immigration consequences and strategies to avoid them for their clients.
Well, I just want to thank our excellent speakers, Benita and Dan, and thank everyone for watching and our live studio audience here today. And also to remind everybody to tune in tomorrow at 1 p.m. Eastern to watch the immigration consequences of domestic violence and related cases. Thank you.
Thank you.